So we will continue from where we left in the last class. We were discussing about rights. Uh, we are going to look at certain definitions of rights. Specific definitions are not that important. As long as you understand the concept. But still, because you're asked all these questions in the examination, I will mention a few which are quite often asked. So, in the last class, we tried to define rights, and we tried to define rights in terms of interests. Then you said that not all interests are considered as rights, only those interests which are legally protected can be considered as rights from a legal perspective. Uh, well, you can say the same thing about moral, rights from a moral perspective. Certain interests are also probably, recognized from the moral, point of view. You can say that, well, those are moral rights. Anyway, so we saw that rights and interests are very much related. The content of rights are certain interests which are legally protected, from a legal, perspective. However, not all interests are protected. And why is that? Well, certain interests are protected, certain other interests are not protected. Now, I think this is a question that I had asked in the last semester as well, in the context of what Roscoe Pound, talks about. He talks about, judges' business to, reconcile conflicting interests. He does not talk in terms of rights. He says that, well, when a judge has to decide a case, when the cases come before the judges, they are to look at different kinds of interests, and then they reconcile those conflicting interests. Okay, so he talks about different kinds of interests and how you have to bring them on the same plane in order to proceed, preferably on the social interest plane, and then reconcile them. So that's a particular way of looking at what judges do. Well, the other way of looking at the problem is this, that, well, we say that when it comes to the legal systems and what judges do, they essentially, whatever the matter is, it's essentially about determination with respect to certain rights. Okay, whatever the right it is a matter of determination of certain rights. So you can say that rights constitute the atomic or maybe even subatomic particles of the legal world. Okay, so something like that. Whereas there are others who say that, well, no, what the hell are rights? Okay, if not interests. But then, what difference do we really see? I mean, between these two, use of words, rights on the one hand and interests on the other. Well, there could be different kinds of interests. Okay, some interests are protected, certain other interests are not protected, as one of you had pointed out yesterday. So, and rights, quite often, when we talk in terms of rights, they quite often involve protection of certain interests as opposed to certain other. But here's the thing, when it comes to adjudication, okay, with respect to a particular matter, judges do not merely say that, well, we are protecting certain interests at the cost of the others. Okay, they say that we are deciding in favor of certain rights. Okay, right that belong in someone. Okay, so when that is done, okay, when that is said, what does it essentially mean? It essentially means this, that when you talk about something as a matter of right, okay, it's not just any other ordinary interest. There is something special about rights, okay, that you cannot completely equate with any other ordinary interest. So rights have some kind of peremptory force. Okay, it has some kind of superiority over any other claims that one can make. Okay, any other interest that you can think of. Okay, when you think of certain interest in terms of rights, okay, that has some kind of peremptory force. Okay, it is more important than any other other conflicting interests. So it's not merely, okay, you have different interests, you reconcile between them. Not just that, okay. So maybe it's not that, okay. So for example, I as an individual have certain rights. Okay, so maybe I have certain right with respect to certain property. Now, it is possible for the legal system to, appropriate that from me and then use that for the benefit of you know, the state. Okay, but that's not how things actually work. Even when my property can be forcefully taken away from me, and for the greater benefit of a bigger community, that's not what actually happens. Okay, even at the cost of that greater benefit, protection is given to my property. Okay, so oh, there's too many interruptions here. Sorry. Hello, class ma'am, tisat kotha ko? So anyway, you see that when you have a right, okay, obviously the content of it is some kind of interest, but those interests have some kind of peremptory force. Those rights have some kind of peremptory force. So you do not equate them with just any other interest, okay? And then you do some hedonistic calculation and then say that, well, if this right is sacrificed, it leads to some greater happiness, greater benefit. You don't decide matters just like that. When one has right, it is to be protected, even if sacrificing that would cause larger public benefit, larger greater happiness. That's not what really happens. So rights have some peremptory force. So yeah, obviously right consists of certain interests. So those interests which are protected, okay, as a matter of right, those interests are weightier, okay, those are heavier, okay, interest than any other ordinary interest. Okay, so this is what rights thinkers, okay, thinkers who talk in terms of rights, okay, have talked about. So you discussed about Ronald Dworkin, and Dworkin talks about rights as trumps. Okay, so rights are like trump card. Okay, when you talk about rights, they have some value, they have some force which is much higher than any other claims or any other interest which might come in conflict with that. Okay, so when you talk about rights, it's not just any other ordinary interest. Okay, it's not just any other ordinary interest. When you talk about rights, it has some greater value than any other. It has some weighty, higher weight. Okay, it is weightier consideration than any other ordinary considerations. So that is essentially what rights all about. Now there are other jurisprudential discussions, deliberations on this. I don't want to pull it that far, but if you're interested, then all these debates are available to you in your books that I have suggested. So just go there and read them. So just remember for now that rights are not to be, as we understand here, are not to be equated with any other ordinary interest. Okay, but when I say rights have peremptory force, okay, that they are weightier consideration, does that mean that there are no possible situations in which such rights can be sacrificed for some larger public benefit? Well, that's not the case either. Okay, so that in law of tort, for example, you have studied about public necessity as a defense. Okay, so in those situations, that, for example, in order to prevent a fire, okay, you might need to take down a portion of someone else's house, okay, in order to prevent a huge conflagration. Okay, so that happens. Okay, in such case, this party can say that, well, I have a right to property and you have no business, okay, bringing it down without my permission. Okay, now what is the difference in that situation? In that situation, the difference would be, well, larger public benefit and all that. So that yes, rights do have peremptory force. They are weightier, they are weightier interest, okay, compared to any other interest. But nonetheless, okay, there might arise situation where it might be necessary for the legal system, to sacrifice some individual right for larger, benefit of others. Now, this is not an uncontroversial remark that I'm making. Okay, many would disagree, who would say that, well, in no cases, I mean, if I have a right, there will be in no case will it be justifiable on anyone's part to take that away from me merely because But then even hardcore libertarians like Nazi can all also concede this much, that you can possibly think of situations, okay, when it might be um, it might be necessary that we sacrifice some individual right for the protection of for certain larger public benefit. So that much is considered by many philosophers. If you want to go further, you go into studying utilitarianism, the debates with respect to that, okay, you will find all that in those discussions. But given paucity of time, I cannot go into all those details, but you have the basics to go on your own. So yes, that's what rights are all about. Okay, rights are quite often defined in terms of interest. Okay, so though which interest? Okay, if it is legal right, then legally protected interest. Okay, however, rights and interests are not the same thing. Okay, rights are not merely any other interests that you use them to do calculus and then conclude as to what interests are to be protected. No, rights are certain weightier interests, okay, they have some peremptory force over that of any other ordinary interest. So that's what rights are. Now another question that arises with respect to right is this, that do we have a right to an object or to an interest underlying it? So yeah, so this problem arises. Okay, this question will be answered when we take up Hofel's analysis of jural relations. But usually when we talk about rights, we say that we have a right to something, that I have a right to my mobile phone, I have a right to this book that I'm holding. Okay, not really though. It might be what lay people might understand rights as. Okay, but for law students, okay, for learners of law, for those who practice law, they're not bothered about the object in itself, okay, rather than an interest that underlies, okay, with respect to that object. So when I say, so my right with respect to this mobile phone would be all the interest that I have with respect to this mobile phone. So what those interests could be, my interest in possessing it, okay, my interest in using it, okay. So I have many different interests. So the rights not really with respect to the object, but certain interests which underlie that, okay. So that's how lawyers and law students, law learners should understand rights. So, and then on top of that, rights, you do not have rights only with respect to objects. You can have right with respect to certain relations, okay. So with respect to certain abstract concepts. So for example, your reputation is not an object, so you can have rights with respect to your reputation. So your right that your reputation be not tarnished, okay, is a right that you have, not with respect to any physical thing, not with respect to an individual, not with respect to anything that you can touch. So it's intangible. Nor do we talk about this in terms of any proprietary value. So you can have rights even with respect to abstract concepts. Now, before we go further with the definitions, certain other questions that we need to ask at this stage that we will discuss later on in other topics are these. Okay, so the questions are like this. Okay, so whether we should restrict this idea of rights. So should rights, okay, be restricted only to humans? Okay, what is it that makes humans so special that we talk about rights only in terms of humans? In today's time we talk in terms of animal rights, okay, and various other things, but those are recent developments, okay. So the question that arises, does it make sense to say that all these other beings and entities, they have rights? Okay, does it make sense to say that, or is it our interest in them which is being protected. Now, this question I'm not going to address at this stage. We are going to address this question later on when we talk about legal personality. So yeah, so that's what I would say. The basic introduction to rights would be. Now let us look at some of the other definitions, which have been given with respect to this idea of rights. Okay, more specifically with respect to legal rights. Okay. So you will notice in these definitions that we are going to discuss that they have a particular way, a particular approach to defining rights that you can categorize into two different categories. Okay, we'll look into all that later on. But for now, let's look at the definitions. Okay, so Holland says about legal rights that jurisprudence is specifically concerned only with such rights as are recognized by law and enforced by the power of the states. Okay, so his definition of right, as you can see, is purely about legal rights. Okay, so these are he says that jurisprudence is specifically concerned only with such rights as are recognized by law and enforced by the power of the state. So you can clearly see that he's an analytical jurist and concerned only with analysis of legal concepts. Okay, so how does he define legal rights? He says the legal rights in the strictest sense of that term as a concept. I'll just type the definition for your convenience. Wait just a second. You can. Okay, as you can see there. Okay, he says that his definition is this: that legal right in the strictest sense of that term as a capacity. He says that, well, what is right? He says that it is a capacity residing in one man of controlling with the assent and assistance of the state the actions of others. So what is important here is that he's talking about legal right in terms of your capacity. Okay, he's talking about it in terms of your will. Okay, your capacity. Okay, that resides in you, although he uses the word man. So we'll assume that for everyone, residing in one man of controlling, obviously with the assent and assistance of the state, because he's talking about legal right. Okay, the actions of others. So basically, when so if I have the right, okay, I make your actions non-optional. Okay, so it's kind of imposition of my will over that of you. Okay, now, of course, with the assent and assistance of the state. So the word that is important for us that he uses is capacity. Okay, so it's the capacity residing in one person, I would use, of controlling with the assent and assistance of the state, because it's a legal right, the actions of others. That means it makes someone else's actions non-optional. Okay, so yeah, he says that it could refer to tangible objects, and sometimes it could have no such tangible object as reference. So, but that's not that important. The important part is the capacity that he's referring to. So he's saying that when we talk about right, we have to talk about someone's capacity, someone's power, someone's will. Okay, that kind of definition you see here. A similar definition has been given by another positivist, and his name is John Austin, who you have studied, and he gives this definition. Just a second. So he talks about rights as faculty. Okay, so I would say that I would use it in the same sense as Holland had used. Okay, so he says faculty. Okay, it's the faculty which resides in a determinate party or parties. Okay, so it could be one person or it could be a group of persons. Okay, party or parties by virtue of a given law. Again, that means a legal definition. Okay, and which avails against a party or parties other than the party or parties in whom it resides. So he's talking about emphasizing on the necessities of two different parties. Okay, A and B. Only then the idea of legal right can make sense. Okay, so here when you have two different parties, so one party has the faculty, okay, that resides in that determinate party, obviously with the authorization of the law, okay, that you avail as against the other party, okay. So that's the definition given by Austin. So you see that the same thing, the previous Holland talks in terms of capacity, Austin talks about in terms of faculty, and then we have another philosopher, Gray, okay. Gray talks about John Chipman Gray. He calls it the power. Okay, so you see a similarity here: capacity, faculty, power. The power which a man has to make a person or persons do or refrain from doing certain acts. So right involves, according to him, your power to make someone to do or refrain from doing certain act. So for the power arises from the society imposing a legal duty. So again, legal definition upon a person or persons. So in all these three different definitions that you see, what is important in all of them is whosoever they are saying as possessing the right, okay, have either capacity, faculty, or power. So the essence here is that they are capable of willing. So when I have a right, I should be able to exercise, okay, that right. So I should be able to will that something be done or not done, okay. That's a very important aspect of these definitions that we just saw. Now remember this, as this will be relevant later on as well. Yes, any question?
Excuse me, sir. What is the gray definition?
So I just put it here. Can you see the power which a man has to make a person or persons do or refrain from doing a certain act? A certain act. Okay. So far as the power arises from a society, so it's legal duty upon a person or persons. So in all three definitions, if you see here, you see Holland using capacity, then you see Austin using faculty, then you see this guy Gray using the word power. So this requires in all three definitions, as you can see, that person in whom the right inheres has to do something about it, okay, has the power, has the capacity, has, so them being able to make certain choice, okay, them having will is very important according to them, okay. So this is the commonality that you notice in all these three definitions, apart from the fact that they are all giving you a legal definition of right, okay. So I have another question. So this means if there is lawlessness or statelessness, there won't be any right. Well, I don't know in what context you are asking, but their definition is being given in the context of a society that exists, okay, and in which you have a legal system. And if you have a legal system, we can talk in terms of legal right, okay. So then they're going to define what are legal rights. So yeah, if you're going to talk in terms of legal rights, that's possible where there is a state and where there is law. If there is no state, no law, then it doesn't make much sense to say that, well, there is a legal right. Well, that does not mean that rights do not exist, because moral philosophers would say that, well, whether that exists or not, moral rights would still exist. So that's always there. That in no way can be taken away. But that's a separate discourse. But because we are within the legal discourse, these philosophers say that once you have a state and once you have a legal system, then how do we talk about right? Well, this is how we talk about right, okay. This is what you see in their definition. They are just bothered about conceptual analysis. They're not getting into those legal versus moral debate, okay. So are you guys with me till now on this?
Yes, sir.
Okay, so we'll take two more definitions, and those will show you another approach to defining rights, okay. So Rudolf von Eyring, a sociological jurist, okay, who talks about interests, okay. He talks about interests. So remember, most of the sociological jurists talk about rights in terms of interests, okay. They do not look at rights the same way you have this modern liberal thinkers look at rights, okay, as having peremptory force, as having some kind of superior weight, as having some as being Trump and all that, okay. So not like that. So you see, back in those times, sociological jurisprudence has a particular way of looking at it, okay. So Eyring said, as you would expect from him, being a sociological jurist, he says rights are legally protected interests. Okay, he is defining rights as interests, but not every interest. Okay, but legally protected interests. Similarly, Salman says right. Okay, he says, I'll just type it here, it's a longer definition. Okay, he says a right is an interest recognized and protected by rules of right. Okay, that is by legal rules. It is an interest, the respect for which is a duty and disregard for which is a wrong. Okay, the rest is fine. Okay, you know that rights correlate with duty, that's understandable. Okay, so the first part is very important. He says that a right is an interest, okay, which is recognized and protected. So the difference in these two sets of definitions that we have just looked at is that the first set of the first three jurists define rights in terms of your will, okay, your capacity, okay, your power, okay, your faculty. So they were trying to define rights in terms of will, whereas the later two letter to this jurist talks about rights in terms of what? What do you see common in their definition? In the definition given by your Eyring and Selman?
Interest. Rights in terms of interest.
Rights in terms of interest, yeah. So it has a huge implication, okay? It has a huge implication, the way, these two definitions have been given. I'm not going to go into all that as of now. Just keep these two sets of definition and the approaches, that they have taken. We will discuss about two broad theories with respect to rights, okay, later on, towards the end of our discussion on rights. Now, these are the definitions of rights, okay? Now, let's look at certain characteristics that rights possess, okay? Because it is conceptual analysis, we have to break down the idea of rights to its, like different component parts, okay? So, when we talk about rights from this legal perspective, when we talk about legal right, there are certain characteristics that, rights possess, okay? So, the first is that you need a person of inherence, okay? You need a person of inherence. So the right inheres in someone. So let's say that it's person A. So when we talk about right, person A is the person of inherence. Okay, inherence. That means the person A is the subject of right. Okay. Now, as I said, when we talk about right, we need another person. Okay, so that would be person B. Okay. Now person B is known as the person of incidence. Okay, the right is incident upon that person, and you can call that as the subject of duty. Okay, so right duty correlates, remember, and you need two different parties. Okay, so that's the second characteristic. The third is that when we talk about rights, okay, the right has certain content. Okay, so what is that content? The content of right is that of act or omission. Okay, so the duty bearer here is expected to do or abstain from doing something. So that is the content of the right. Okay. Now the fourth characteristic which is identified is the object or the subject matter of the right. Okay. The right is with respect to something, okay? That thing need not be a material thing, okay? It could be immaterial, it could be some abstract idea. So whatever it is would be the subject matter of right. So it could be your intellectual property. The right could be with respect to some intellectual property. But then I'm giving you a very broad definition of right. Once we go from here into Hofeld, you will see that, well, these characteristics that we are discussing are problematic in themselves, but just for the sake of your knowledge, keep this in mind. Okay, so person of inherence or the subject of right, person of incidence or the subject of duty, then you have content, that is act or omission, and then you have object or the subject matter of the right, that is with respect to the thing. It could be abstract, some concept, it could be material object, it could be immaterial as well. But you have an object of right, and then certain facts or events that create that right. Okay, so for example, if you buy a particular piece of property, okay, the process, okay, by which the title to the property is vested in you, okay, basically the process through which the rights are vested in you are the facts and events that create the rights here. So these are the elements which are identified by Salmond, okay, in his book, that he calls as the different characteristics of rights. So you have these 5 different characteristics which are identified. You have person of inherence, you have person of incidence, you have a content, you have the object or the subject matter of the right, and then certain facts and events that led to the vesting of that right in the person of inherence. Okay, so these are, I mean, if you break down the idea of rights, these are the characteristics that you come across as Salmon would ask us to believe. Well, certain other questions that arise. Okay, is it necessary that the person of inherence has to be there? Can there be ownerless right? Okay, could there be contingent right? We will look into these questions later on when we take up other topics. Okay, you will find this there. Okay, but just remember this, that law does not seem to be comfortable with the idea of ownerless right. Okay, the right has to be there, and if right has to be there, then there has to be an owner of that right as well. Only in exceptional situation you will see that some kind of protection of rights of those people who do not exist are provided by the law. We will look at that later on. So yeah, that's the introductory discussion about rights. So do you guys have any confusion with respect to this so far?
Sir?
Yeah.
Sir, what is the 5th characteristics?
See, when we talk about rights, okay, some event, okay, some facts or some event, okay, lead to the vesting of that right. So when you say that I have a right, okay, what fact, okay, what events create that right? Okay, some event creates that right. So when we talk about, for example, if you're claiming a proprietary right with respect to something, so you have the title to that property, and with respect to that title you are claiming certain right. Okay, so the vesting of that right in you happened by you acquiring a title to that property. Got the idea? So some facts, some events. So if you're talking about other rights, so for example certain fundamental rights you're talking about, well, how do you have that? Okay, well, it does not have to happen while during your existence. Well, some fact had already happened, so the constitution had already given you the protection, so that fact creates the right in your favor. So when you are born, the fact that you are born as human, okay, and the fact that you are one of the inhabitants of the country, certain fundamental rights are available to you. So whatever the facts, certain facts and events lead to the vesting of the right in you. So that's what has been said here by our jurist, Salmi. Yeah. So is that clear? This is basic. Yeah. Hush.
So aren't the 3rd and 4th element somewhat similar?
The third element is what it requires you to do or to omit or to not do. Okay. So the content of the right is that you either do, that you pay me rupees 10, or you do not enter into my property. So I'm giving you 2 examples of what the content of the right could be. So for example, you owe me rupees 10, then the content of the right that inheres in me would be that you pay me, so you have to act. Okay, so you pay me rupees 10. If the content of my right is that you do not enter into my property, that you do not trespass my property, the content of the right would be that you omit, okay, you avoid entering into my property. So that's the content. Okay, now the right with respect, the right that I have just referred to, okay, is with respect to what? In the second example that I just gave you, is with respect to the property, okay, the landed property, for example. Okay, and with respect to the first, it's the money that that I am owed to. Okay, so you see that in the first case, it's not specific note I'm referring to, but something that is owed to me. So it's something of value, something of monetary value. So rupees 10 in this particular case. Okay, so that would be the object. So do you see the difference between content and object?
Yes,
These
sir.
are not the same thing. Okay, the first
Yes.
is some act or omission. The second is the thing that we are concerned about, the object or that we are concerned about. That's what Salmon says. But as we proceed, as we study Hofield, you will see that, well, you will find lots of problems with identification of these characteristics. These were characteristics which were identified in simpler times. Okay, now we have much complicated definition of rights. Now we have much complicated analysis of the idea of right in the works of Wesley Newcomb Hofield. Okay, now this fella has done some very groundbreaking work when it comes to jurisprudence of conceptual rights. He basically breaks down this idea, okay, and then tells us that when we so the idea is that, okay, what he has done is developed a legal vocabulary for us. Quite often we use the word right in such a way that when we use them even in a different contexts, we are conveying the same thing. Okay, so he's saying that that's nonsense. Okay, mm, when so he basically gives us a very detailed vocabulary of what to be used in what situation. Okay, something of that sort has been done by him. So that's what we are going to study. Okay, so is a famous jurist by the name Wesley Newcomb Hofield. Okay, he was a professor at Stanford University, and he published some very important articles, okay, in which he did this jural analysis, okay, analysis of jural relations, and that landed him a very good job at Yale. uh, and well, those are not that important. Why am I talking about this? Because you guys need to know, but do not reproduce all this in the examination. That's what my worry is. Okay, so in examination, students write exactly what's there in the book and in exact reproduction of the sentence as well. So, I mean, I don't know what to say. Anyway, forget about all that. Uh, these are just for your information's sake, nothing more. Okay, address the question which is asked. Okay, you don't have to write 5-10 pages just to prove a point that you have studied. Okay, the more you do that, the more suspicious we are. It's as simple as that. uh, so yeah, try and understand what you are asked and attempt the answers accordingly. So the next topic of discussion for us would be Hofield's analysis of jural relations. So I told you who Hofield was, and he has done very some path-breaking work in when it comes to analysis of this idea of rights. Okay, so Hofield was dissatisfied. He was not happy with reduction of all legal relations. So at the end of the day, when the judges decide a matter, they decide those matters in terms of legal relation that exists between party A or party B. Okay, party A or party B. That's what it does. Okay, so he's saying that the legal relation that exists between party A and party B, all such legal relations cannot be termed as the relation of rights and duties. Okay, so that's nonsense. Not every such legal relations can be called as relationship of rights and duties. Okay, he breaks this idea of rights into four different four other different types. Okay, other kinds. Okay, we will go into all that, but before that, let me tell you why he had done it. Okay, so one of the problems that we come across, okay, as students of jurisprudence, as students of law, is that, well, there used to be this classification of rights as rights in rem and rights in personam. You probably have studied this already earlier. Okay, I have a question. Just a second, sir. Would the right to privacy come under category of content? I mean, when you talk about right to privacy, sorry, Disha, I missed your question earlier. Okay, well, Disha, if you are listening to me, What did I say
Yes, sir.
are the contents according to uh, our philosopher, Selman here? What does he say?
So you gave the example of the trespassing where there is like there's an object that needs to be protected.
No, don't talk about. You have to speak in precise terms. Okay, there is no question of protection. The when I say that I have a right that my property is not interfered with, you have a duty not to interfere. So when I say that I have a right that you do not trespass into my property, you have a duty not to trespass into my property. You have to use such precise words. The moment you talk about protection, it conveys something else. So this is something that you should know early. uh, uh, so I talked about content in terms of what? I mentioned two different words when I talked about
So
content.
commission and omission.
Acts,
Okay.
omission.
Acts or omission. Okay. So in the case of trespass, what is the content of that right? Omission. Okay. So that's the case. Okay, that's the case. Whereas in the other example that I gave, that I'm paid rupees 20. Okay, what is the content there?
Commission.
Okay, so yeah, so someone has to act, someone has to do something about that. Okay, so that's the content. Okay, it's either act or omission. Okay, now when you talk about right to privacy, okay, now this creates certain problem for us. Okay, but let's say that, well, you have a right to a private life. Okay, so what would be the duty imposed on the other side?
Not to commit anything that interferes with it.
Yeah, you can use it in both the sense. Okay, not to do something that would interfere with my privacy, or omit from doing something, okay, that would interfere with my privacy. Either way you can speak it. Okay, not a problem. So do you understand what the content would be there?
Yes,
So
sir. Yes, sir.
would be to not do anything. Okay, so you do not do something that would interfere with my privacy. So you can say that, well, the content here would be to not do something with respect to my right to privacy. Okay, is that clear?
Yes, sir.
Okay.
Yes, sir. Thank you, sir.
So that's the content. Okay, so your question, would the right to privacy come under the category of content? Well, the right to privacy itself is not, but the content with respect to right to privacy, as you have just told me, is the duty to not interfere. Okay, so duty to abstain. Okay, duty to omit. Okay, interference. So that's the content that I see here with respect to the example. So it's not the right to privacy itself, that comes under the category, but that specific omission, okay, is the content here. So I hope you are with me, all of you with
Yes,
me.
sir.
Okay, so yeah, just a second. So we discussed about we were discussing about Hofeld. Okay, so Hofeld talks about he essentially tells us that, well, not every legal relation can be talked only in terms of relationship of rights and duties. There are many other legal relations that arise. Okay, but you need two different parties. Okay, only then can we say that there is a case of legal relation. Okay, so and then he breaks down this idea of rights that we broadly, generally, throw around, use, okay, into four different specific kinds. Okay, now why he does that? I was discussing that. So one of the problems that he came across, okay, was this categorization of rights into rights in rem and then rights in person. The distinction, as is understood, is this: that when we talk about right in rem, it, because you have the word rem here, re means things. So the earlier understanding was that rights in rem were in respect of things. Okay, in respect of things. So whenever we talk about rights in respect of things, you may say that, well, it's the case of right in rem. Whereas right in personam are the rights that you have as against specific individuals. Okay, or a specific group of persons, whatever. Okay, So this is how right in rem and then right in personam was understood. But another way we look at right in rem is this, that we say that when we talk about right in rem, it is a right that we have as against the rest of the world. Okay, whereas when we talk about right in personam, it's a right that we have against specific person or specific group of persons. Okay, so Hopeful had difficulties understanding this idea of right in rem, that when I say that I have a right with respect to a particular thing, what the hell do I really mean? Okay, that's problematic. The legal relationship cannot be defined in terms of the thing itself. Okay, remember earlier I told you that we talk about rights in terms of an interest that underlie rather than the thing itself. Okay, this is what he thought. Okay, along with that he said that how can I have a right and then the entire world has a have a duty with respect to it. Okay, the legal relationship has to be between two different determinate parties. Okay, the relationship cannot be between me and the rest of the world, because the rest of the world, what the hell is that? So this is the problem that he noticed with the use of the word right in rem. So he said that what we call as right in rem are not really, the duty that the rest of the world possess, okay, has as against me, but the duty that each individual, okay, who might, okay, have the who might what he is essentially saying, that let's not look at the world as one entity, okay, rest of the world, rather than whosoever are the persons who are there, okay, they each have a duty with respect to me. So this is what he says. Okay, so right in rem is nothing but maybe 7 point what's the number, I don't know, maybe 7 billion people having duties with respect to me. So you can say that there are 7 billion rights in person when we talk about rights in rem. So that's what he's talking about, that when we talk about rights, it has to be a legal relation. Legal relation has to exist between two different determinate parties. Okay, and this rest of the world is not determinate, it's indeterminate, so that cannot be the case. So that's why he breaks down this idea of right in rem into all these different rights in personam which could exist. Okay, so that's there. Apart from that, there were other difficulties that existed. Okay, so especially when it comes to trust. Okay, so in law of trust that you are going to study later on, what happens is that, well, so for example, I entrust person A to hold the property on behalf of the beneficiary B. Now you know that the problem is we with respect to the trustee, we are sure, okay, the trustee has the rights, as against others. What about the rights? What about the right that beneficiary B has as against this fellow, that is the trustee? Okay, what is the nature of that right? Is it right in rem or is it right in personam? So Hopeful would say that, well, that problem would not even arise if we give up this distinction of right in rem and right in personam, and instead look at this as specific, legal relation that exists between determinate parties. So that problem would not even exist. Okay, so this is what Hopeful tried to achieve. So later on, when you study, in law of equity and trust, you will see importance of Hopeful's analysis there. And if I'm teaching, then I will share Hopeful's article with respect to this later on. But at this stage, this should suffice. So you know in your head that he was not quite happy with calling every legal relation a relation of right and duties. Okay, he wanted to break them down into different legal relation, and then he came up with different kinds of terminologies to be used in those precise situations. Okay, and thus he is able to explain many legal predicaments that judges have come across. Okay, and to a great extent he was successful in doing that. There are critics of what he has done, but we will go into that later on. Today we have almost come to the end of the class, but I will just introduce the terminologies that he uses. Okay, So in place of right, okay, that we generally use, okay, he gives us four other different terms, okay. So what are those in place of rights? Okay, he's saying that, well, there is claim right, okay, there is claim right, okay, there is liberty, there is power, and there is immunity, okay. All, I mean, we use right generally to mean all of them, but they are all different, okay, they are all different, they convey different idea, they convey different legal relation, okay. So remember these four in place of right, okay, that we generally use. We're saying that there are four different terminologies that we should appropriately use, okay. What are those? Those are claim rights, or the right in strict sensu, okay, right in strict sense, claim right. Then there is something called privilege or liberty, okay, whichever you want to use. The other kind is privilege or liberty, okay. The third one is power, okay, and the fourth one is immunity. And we quite often use all of them as, as being rights, which is not correct, as he will show us, we will see in our subsequent discussions. Let's also look at how they are correlated, okay, with other concepts that he shows us. So what is the correlative of right, as we discussed so far? Can someone tell me what is the correlative of a right?
Interest?
No. Interest is the content. Do not forget the word.
Duty.
Yeah, correlative of right is duty. Okay, I said the other day that duty is not the opposite of right. Okay, I said in the previous class that duty is the correlative of right. You have to listen very carefully. These are very important. So the rights, okay, are, correlated with duty. So here, when he talks about claim right or the right in strict sense, okay, it is correlated with duty, okay. Then we have another kind, okay, that he calls privilege or liberty, whatever you call. What is the correlative of that? The correlative of that is no right, okay. The correlative of liberty or privilege would be no rights, okay. Now this is a little confusing, I understand. You might say that, what do you mean by no right? I'll explain this tomorrow. Then we have the third one known as power. The correlative of power would be liability. So if I have, sorry, I'll explain that. And then fourth, the correlative of immunity is disability, okay. The correlative of immunity is disability. Now what do I mean when I say correlatives? It basically means that if I have a one of the correlatives, then the other one would be in person B. So if I have right, then person B has duty. If I have liberty, then person B has no right. So if I have power, then person B has liability. If I have immunity, then person B has disability. So this is the relation of jural correlatives. Now it's not that simple, it's just introductory. Tomorrow I will explain this in detail. Just remember, when we talk about correlative, if A has one of the correlatives, the other correlative would be in B. So that's how it works. Yes, Danish, what is it?
Sir, but you said no, the correlative of this liberty is no right. But in today's scenario, normally when we see the people, when they talk about liberty, they are talking about preservation of rights, and they demand rights for other groups which are not given rights so much. So in today's, well, in practical sense, when we see that liberty is related with right. But here, how is it possible that liberty is related with no right?
No. So what does this mean? So when I say I have a liberty, okay, so the relation goes like this. Maybe this will explain what I'm trying to say. I said when I have a right, then you have a duty to do or not to do something. Now similarly, when I say that I have a liberty, that means you have no right that I do not exercise my liberty. Okay, got the idea? So if you have a right, that I do not exercise my liberty, then I do not have my liberty. Okay. Now, if I have a liberty, you do not have a right that I do not have do not exercise my liberty. Got it, Danish?
Sir?
Okay, so obviously you will be confused because we are doing jural analysis, is conceptual analysis. The normative questions will be asked later on. For now, forget about all those real life questions. We will come back to real life questions later on. When we talk about liberty, it essentially means that I have the choice of either doing something or not doing something. If someone has a right that I do or do not do something, that then I do not have a choice. That means I do not have a liberty. So when I say I have a liberty, that means someone else has no right that I do not have a choice. So that's why I have a liberty. So that's what the relationship is essentially all about. I will address this tomorrow. Yeah, Sumit, what was the question?
Sir, there's no question, but sir, I have an example of liberty. Sir, a police officer arresting a criminal. Here, the police officer has the liberty to arrest him, but sir, the criminal is very much dormant here. So I think
that's the power of the police station. Sorry, so the power of the police officer to make arrest is a case of power, not of liberty. Although it has the nature of it has certain nature of liberty, but it is a case of power rather than liberty. So when you talk about liberty, the correlative on the other side would be liability. So if the police officer has the power to arrest, the other person is liable to being arrested. Okay
sir. Thank you.
So yeah, I will explain the whole thing tomorrow. It's going to get you confused. It takes time, but you should try and understand this, because once you do, then you will remember forever. I did not have anyone explaining this to me when I was doing my LLB, because there was no one teaching me properly. We